like to call the Senate back to order. I'd like to have everyone's attention in the chamber and ask that all senators please take your seats and cease all audible conversations inside the chamber. While we're doing that, I'd like to recognize our Secretary of State, Brad Raffensperger, who's joined us here today. Thank you, sir, for coming up to the Senate chamber. It's a great honor of mine to be able to participate in this process today. We have with us today the newest member of the Georgia Senate, Cardin Summers, and along with him, he's joined by his lovely wife, Janice, Jade, his daughter, Weston, his son, and other family and friends. So thank you on behalf of the Senate for coming and joining us today. I want to congratulate you on your election, and I know that you will find your experience here to be one of the most rewarding experiences of your life. And as I mentioned earlier, you have incredibly large shoes to fill. There's a gentleman here that was as respected as any person I've ever seen in this building. And so thank you for joining us. Mr. Secretary, at this time I'd like to ask that you read a communication from the Secretary of State.
I, Brad Raffensperger, Secretary of State of the State of Georgia, do hereby certify that the attached one page lists the results as shown on the certified consolidated returns on file in this office for the special election held on March 3rd, 2020 in District 13 for State Senator in Crisp, Dodge, Dooley, Lee, Sumter, Tift, Turner, Wilcox, and Worth counties. Having received the majority of the votes cast, Cardin H. Summers was duly elected to this office. In testimony whereof, I have set my hand and seal hereto. Respectfully submitted, Brad Raffensperger, Secretary of State.
We are additionally honored today to have with us a Justice of the Supreme Court and, equally as important, a former member of this body to administer the oath of office to our newest senator. Justice Charlie Bethel is a widely respected jurist. Justice, I have a long-winded bio here of you, but this body is well versed with your ability and your talents. So thank you so much for joining us. At this time, I'd like to ask that Senator Summers proceed to the well and administer the oath of office from our justice.
Thank you, Senator. I want to congratulate you on your election. I ask, are you prepared to take your oath?
Absolutely.
Please raise your right hand and repeat after me. I do hereby solemnly swear
I do hereby solemnly swear
or affirm that I will support
that I will affirm and support
the Constitution of this state
the Constitution of this state
and of the United States,
and of the United States,
and on all questions and measures which may come before me,
and on all questions and measures which may become before me,
I will so conduct myself
I will so conduct myself,
as will in my judgment
be
most conducive to the interests and prosperity of this state.
be most conducive to the interests and prosperity of this state.
I further swear or affirm
I further swear or affirm
that I am not the holder of any unaccounted for public money
that I'm not the holder of any unaccounted for public money
due this state or due any political subdivision or authority thereof,
due this state or any public subdivision or authority thereof,
that I am not the holder of any public office of trust
that I'm not the holder of any public office or trust
under the government of the United States,
under the government of the United States,
of any other state,
of any other state,
or any foreign state,
or any foreign state,
which by law I am prohibited from holding,
which by law I am prohibited from holding,
that I have been a resident of my district
that I have been a resident of my district
for the time required by the Constitution and laws of this state,
for the time required by the Constitution and the laws of this state,
that I am otherwise qualified to hold said office
that I'm otherwise qualified to hold said office
according to the Constitution and laws of Georgia.
according to the Constitution and laws of Georgia.
So help you God.
So help me God.
Congratulations.
Thank you, sir. Thank you. Thank you. Thank you. Thank you. Walk up with me. Look at me, Weston, walk up here with me. He's taking pictures. I'm sorry. Thank you.
I didn't want to miss it.
Thank you. And thank you all for coming today. Thank you very much. Very kind of you.
Congratulations, Senator, and congratulations. Would you like to address the body for a moment?
Gentlemen, this has been a lifelong dream of mine. I'm sure you serve the same type purposes I do. I come to do things and be a team player and be fair and be just. I want what's right for Georgia. I want what's right for America, and I intend to stand up for those kind of values. And I promise you, if you come to me and you talk to me, I will do my level best to always give you my undivided attention. Thank you so very much for having me.
Thank you, Senator. Thank you, Justice Bethel, for joining us also. Is there objection to the seating of the senator? The chair hears none, and the Senator Summers is seated. Thank you so much. All right, we're back onto the rules calendar. Mr. Secretary, can you please read the caption of Senate Bill 344?
Senate Bill number 344 by Senator Mullis of the 53rd and others. Bill to be titled an act to amend Code Section 241360 of the OCGA relating to order requiring prisoners' delivery to serve as witness or criminal defendant generally, expenses and prisoner under death sentence as witness so as to provide that certain proceedings may be conducted by video conference. Amend Article 6 of Chapter 3 of Title 35 of the OCGA relating to Division of Forensic Sciences so as to provide that employees of the State Crime Lab or associated laboratories may appear by a video teleconference in certain proceedings in court and for other purposes. Mr. President, on March 2nd, 2020, the Senate Committee on Judiciary recommends that this bill do pass by substitute. Respect submitted by Senator Stone, the 23rd chair. Mr. President, the Senate Committee on Judiciary offers the following a substitute to Senate Bill 344, a bill to be titled an act to amend Code Section 241360 of the OCGA relating to order requiring prisoners' delivery to serve as witness or criminal defendant generally, expenses, and prisoner under death sentence as witness, so to provide that certain proceedings may be conducted by video conference, provide for requirements for such proceedings, to authorize judges to order a prisoner's appearance in court and for other purposes.
Chair recognizes this. We have additional.
Mr. President, Senator Hillary of the 19th, Mullis of the 53rd, and Perrin of the 42nd offer the following amendment number 1 to amend committee substitute to Senate Bill 344 by striking line 29 and inserting I, probation revocation hearings and felony cases in which the probationer admits the violation and in all misdemeanor cases. That completes the order, Mr. President.
Chair recognizes the senator from the 53rd to speak to the bill.
Thank you, Mr. President. Also, I'd like to thank the senator from the 13th, because without his invitation, I don't think I'd be here today. As he mentioned that earlier, thanks for being here. I see he's not paying attention, which is the first strike against him. Mr. President, I have a great bill here. This saves taxpayers money and also helps people keep safe. I'll give you the nutshell version. This is a bill that's brought to me by the Department of Corrections that allows video conferencing for certain violations with an inmate in prison that has to go before court. He or she can do this video conferencing with a court that in a nearby city or a city hundreds of miles away. As you can imagine, it will save lots of money and maybe lives for the video conferencing. Senate Bill 344 confides parts of the uniform rules of the Superior Court. Already this is happening in some areas, and it is working well. This allows for the inmate to appear in court by video conferencing from a prison. It also allows a private line so the legal counsel can talk privately with his or her client. This also also permits employees of the State Crime Lab, which you know is well over asserted sometimes with too many cases to deal with, to also appear via conference for all these similar proceedings that I'll talk about shortly. This needs to be in statute. The uniform rules only apply to Superior Court judges, and we changed it so it applies to all court proceedings, local and county and so forth in that regard. This will save millions of dollars and will save lives. And also make sure that inmates have their legal process to make sure that they have all aspects of the law to be sure to be fair with. This saves money for the state and the counties by eliminating transportation, housing costs, as well as reducing the security risks. As you know, in Putnam County, 3 years ago, 2 correction officers were moving an inmate to appear in court. Something went wrong, and the 2 correction officers were shot and killed by the inmate that they were transporting. This definitely will save lives. The money, the tax dollars they'll save will be amazing. They've been doing this since July, and already they've had over 132 video conferences with a savings of driving 37,000 miles since July. You can imagine the money and cost that is in regarding of that. Of course, whenever you transport an inmate, you have to have at least 2 correction officers, whether it's county, city, or state. This is a modern, intellectual thing to happen. This can happen by video conferencing as well as it could in person. If the lawyer of the inmate wants to have it in the courtroom with the inmate there, they can appeal to the judge, and the judge has all the authority to make the decision. All participants must be able to see and be heard and clear for the communication simultaneously with the court and at the prison or the local jail, wherever this is taking place. Already, the Department of Correction has video conferencing in every prison at a cost of $11,000 for the equipment and $3,000 for the upgrades and technology. All participants must be able to the attorney and the client privileges will be preserved, including private communications, as I said earlier, with the offender, with his and her lawyer. Now, again, this is a huge money saving. The rights of the prisoner or the inmate is still administered by the Constitution. This will just help in many aspects. Again, if the counsel for the inmate wants to have it in the courtroom of the county in which it happened, instead of for a prisoner to be driven 10, 20, 100, 200 miles, the judge can waive that and make everybody show up in court. Mr. President, I'm sure there are certain questions, and I'll be glad to answer them.
You have no questions.
All right. Thank you so much. I appreciate you.
Senator, you do have a question that I missed. My apologies. Do you yield?
Maybe. Let me say this first, and then we'll go there. You see, there is an amendment with 3 great legal minds on this paper. That is bipartisan, too, so I think the senator from the 19th is going to explain that. Be happy to take questions.
Chair recognizes the senator from the 33rd.
Thank you, Mr. President. Does the senator yield?
Absolutely. To my friend from Cobb County.
The Crown Jewel Colony in Georgia. Just a quick question.
Yes, sir.
If a senator falls short of telling the truth under Senate Resolution 459, will that proceeding be televised?
Well, maybe. If it's in a committee hearing, yes, it would be.
Thank you.
Chair recognizes the senator from the 48th for a question.
Thank you, Mr. President.
Yes, ma'am.
Does the chairman
Don't
yield?
pump it too hard on this one. Okay, go ahead.
I just wanted to make sure I understood that you accept amendment number 1
Yes.
as a friendly amendment, so that is incorporated.
Yes.
Thank you, sir.
Thank you very much for that.
You have no more questions.
I'm delighted, and thank you very much, gentlemen and ladies. I appreciate your support today.
Chair recognizes the senator from the 19th to speak to his amendment. I'm still trying to find the third strong legal mind. I see 2 that jump out at me.
Thank you, Mr. President, members of the Senate. Amendment 1's already been spoken about by the author of the bill. He agrees to it. He's agreeable, amendable to it. All it does is takes on line 29, strikes probation revocation hearings. There was some comment from the members of the minority party who we're happy to work with concerning whether or not that violated the Sixth Amendment Confrontation Clause issues. So what we tried to do there is make sure that only in felony cases where the probationer admits the violation, and then in all misdemeanors would video conferencing be available for probation revocation hearings. Thank you, Mr. President. If there are no questions, I'll yield the well.
You have no questions. Does any other senator wish to speak to the bill or the amendment? The chair sees none. All right, we're going to take up amendment number 1. Is there any objection to amendment number 1? The chair hears none, and amendment number 1 is adopted. The question is on the adoption of the committee's substitute as amended. Is there objection to adoption of the committee's substitute as amended? Chair hears none, and the committee's substitute as amended is adopted. Is there objection or agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. Questions on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 54, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Mr. Secretary, please read the caption of Senate Bill 311.
Senate Bill number 311 by Senator Kirkpatrick, the 32nd, and others. A bill to be titled an act to amend Chapter 1 of Title 31 of the OCGA relating to general provisions regarding health, so as to prohibit patient brokering, to provide for definitions, to provide for exceptions, to provide for penalties, to amend Chapter 1 of Title 33 of the OCGA relating to general provisions regarding insurance, so as to provide that excessive, fraudulent, or high-tech drug testing of certain individuals is not considered a fraudulent insurance act. It's considered a fraudulent insurance act. Mr. President, the Senate Committee on Health and Human Services offers the following substitute to Senate Bill 311. A bill to be titled an act to amend Chapter 5 of Title 26 of the OCGA relating to drug abuse treatment education programs, so as to prohibit patient brokering, provide for definitions, to provide for exceptions, to provide for penalties, to provide for a venue, to amend Chapter 1 of Title 33 of the OCGA relating to general provisions regarding insurance, so as to provide that excessive, fraudulent, or high-tech drug testing of certain individuals is considered a fraudulent insurance act, and for other purposes. Mr. President, Senator Kirkpatrick of the 32nd, Burke of the 11th, and Orrick of the 36th offer the following amendment number 1. Amend the Senate Committee on Health and Human Services substitute to Senate Bill 311 by inserting prior to, quote, a commission on lines 47 to 50 and 53 the following. Any remuneration, including but not limited to. That completes order, Mr. President.
Chair recognizes the senator from the 32nd to speak to Senate Bill 311 and her amendment number 1.
Thank you, Mr. President. This bill relates to the recovery housing industry, which involves recovery residences for people coming out of treatment for substance abuse. Many people coming out of treatment cannot return home for various reasons, and recovery residences play an important role. Drug treatment facilities are regulated by the Department of Community Health. Recovery residences are not currently covered in our law because they do not provide treatment. Florida passed a bill in 2017 putting some guardrails in place, and after that, some of the players moved to Georgia. This bill is an attempt to protect citizens who are in recovery and has 2 parts. Section 1 deals with patient brokering in the substance abuse recovery area and closely mirrors federal anti-kickback language. It prohibits inducements for referrals in this industry. Section 2 relates to high-tech drug testing, which is an important part of the recovery process, but there are abuses that affect this vulnerable population. The bill prohibits unbundling in order to bill for the tests individually, which is much more expensive, and also performing medically unnecessary tests. These facilities play an important role in recovery, and it's time to be sure that they're doing the right thing for our vulnerable recovery community. I've not heard any opposition to this bill. I do have one amendment requested by the Attorney General's office that more closely matches the wording in federal law. I'll be happy to answer any questions.
Senator, you have no questions.
I yield the well.
Senator has yielded the well. Does any other senator wish to speak for the bill or the amendment? The chair sees none. All right, we'll take up the amendment. Is there any objection to adoption of the amendment? The chair hears none, and the amendment is adopted. The question is on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Chair hears none. The committee substitute as amended is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The questions on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 56, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Mr. Secretary, can you please read the caption of Senate Bill 369?
Senate Bill number 369 by Senator Payne of the 54th and others. A bill to be titled an act to amend Code Section 485511 of the OCGA relating to returns of public utilities to Commissioner of the Department of Revenue, itemization of fair market value of property, other information, and apportionment to more than one tax jurisdiction to require electronic transmission of returns to the Department of Revenue by public utilities and for other purposes. Mr. President, on February 27th, 2020, the Senate Committee on Finance recommends that this bill do pass by substitute, respectively submitted by Senator Huffstetler, 52nd Chair. Mr. President, the Senate Finance Committee offers the following substitute to Senate Bill 369, a bill to be titled an act to amend Code Section 485511 of the OCGA relating to returns of public utilities to Commissioner of the Department of Revenue, itemization of fair market value property, other information, and apportionment to more than one tax jurisdiction to require electronic transmission of returns to the Department of Revenue by public utilities and for other purposes. That completes the order, Mr. President.
Chair recognizes the senator from the 54th to speak to Senate Bill 369.
Thank you, Mr. President. My friends and colleagues, I bring to you a truly simple bill after a long afternoon of debate and long bills, but a needed change to reflect the Georgia of the 21st century. Under current law, a CEO of any public utility must make an annual return of all its properties located in our state to be submitted to the Commissioner of Georgia Department of Revenue. Senate Bill 369 simply moves to require that the CEO of a public utility file such annual return by electronic means. This bill establishes greater efficiency in such reporting and adds to the code the language to reflect that that majority of the public utilities are already doing. Senate Bill 369 passed out of Finance with bipartisan support and by unanimous vote in favor. The Department of Revenue is in support of this bill, and there's no expressed opposition. Mr. President, if there's no questions, I will yield the well.
Senator, you have no questions.
I ask for your favorable support. Thank you.
Does any other senator wish to speak for or against Senate Bill 369? The chair sees none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none, and the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill by substitute. All those in favor of the bill vote yea. Opposed, nay. The secretary will unlock the machine. I think even you can make this one. You got 18 seconds. On the passage of the bill, the yeas are 55, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Mr. Secretary, can you please read the caption of Senate Bill 391?
Senate Bill number 391 by Senator Kirkpatrick the 32nd and others. A bill to be titled an act to amend Article 1 of Chapter 24 of Title 33 of the OCGA relating to general provisions regarding insurance so as to require health insurers to provide coverage for early refills of a 30-day supply of certain prescription medications under certain emergency situations and for other purposes. Mr. President, on March 2nd, 2020, the Senate Committee on Health and Human Services recommends that this bill do pass, respectively submitted by Senator Watson, the first chair. That completes the order, Mr. President.
Chair recognizes the senator again from the 32nd to speak to Senate Bill 391.
Thank you, Mr. President, fellow senators. Senate Bill 391 is about prescription refills during a state of emergency, such as a hurricane. Many times people evacuating during a disaster will need to fill their medications before leaving, but it may be early as defined by their insurance carrier. This bill would waive refill too soon limitations under two conditions. One, the governor has declared an emergency, or two, there's a hurricane warning in effect. The prescription would have to be refillable, and it could not be a Schedule II drug. The pharmacist would need to notify the prescriber within 48 hours of the refill. As a member of the Medical Association's Medical Reserve Corps, I have personal knowledge of the problems caused by people not being able to refill their medications before evacuating to a shelter or other locations. This bill should streamline the process of making sure that patients continue their essential medications during a disaster. I'd be happy to answer any questions.
Senator, you have no questions.
Thank you, I yield.
Does any other senator wish to speak for or against Senate Bill 391? The chair sees none. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. The question is on the passage of the bill. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 55, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Secretary, please read the caption of Senate Bill 439.
Senate Bill number 439 by Senator Brass of the 28th and others. A bill to be titled an act to amend Chapter 11 and Title 15 of the Official Code of Georgia annotated relating to the Juvenile Code so as to provide for enhanced notice to and approved participation of foster, pre-adoptive, and relative caregivers in certain hearings. To provide for the court's consideration of issues relevant to a child's placement, care, well-being, and permanency raised by such persons and for other purposes. Mr. President, on March 2nd, 2020, the Senate Committee on Judiciary recommends that this bill do pass. Respectfully submitted by Senator Stone, the 23rd chair. That completes the order, Mr. President.
Chair recognizes the senator from the 28th to speak to Senate Bill 439.
Thank you, Mr. President, members of this body. Senate Bill 439 is simple. Current law requires that foster parents and caregivers be allowed to be heard in any kind of proceeding, whether it be a dependency case, adjudication hearing, TPR hearing, or disposition hearing. So what this simply does is it puts a process in place to make sure that they are being heard by the courts or having to do this in writing. That could be either in the form of a letter, or we're also allowing it to be in the form of an email, should the recipient agree to that. So, with that, I'll yield for any questions.
Senator, you have no questions.
Thank you. Yield the will.
Does any other senator wish to speak for or against Senate Bill 439? The chair sees none. Is there objection or agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none, and the report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, the main question is ordered. Question is on the passage of the bill. All those in favor of the bill will vote yea, opposed nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 54, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Secretary, can you please read the caption of Senate Bill 442?
Senate Bill number 442 by Senator Ligon of the 3rd and others. A bill to be titled an act to amend Title 44 of the OCGA relating to property so as to prohibit amendments to Property Owners Association instruments and covenants that restrict rental of residential lots and plots and for other purposes. Mr. President, on March 2nd, 2020, the Senate Committee on Judiciary recommends that this bill do pass by substitute, respectfully submitted by Senator Stone, the 23rd chair. Mr. President, the Senate Committee on Judiciary offers the following substitute to Senate Bill 442, a bill to be titled an act to amend Title 44 of the OCGA relating to property so as to prohibit amendments to Property Owners Association instruments and covenants that restrict rental of residential plots and lots and for other purposes. That completes the order, Mr. President.
Chair recognizes the senator from the 3rd to speak to Senate Bill 442.
Thank you, Mr. President. Senate Bill 442 applies to the Georgia Homeowners Association Act, and basically it provides that properties that have been used as rental properties would be grandfathered in to any change that would outlaw or prohibit the use of properties as a rental property. And sometimes you have people that have bought a home in a subdivision in reliance on the existing covenants, and they rent it out as an investment, and then those rules are changed and they're stuck, and they can't, they lose on their return. I'll be glad to answer any questions.
Chair recognizes the senator from the 13th for a question.
Just want to say it's a nice bill. Thank you. Senator.
State your question.
Yes, sir.
My mic. Senator, you for a question?
Yes, sir.
That's the bill we talked about in caucus this morning.
Yes, sir.
Thank you.
Well played. Chair recognizes the senator from the 42nd for a question.
Thank you, Mr. President. Will the senator
Yeah.
yield?
Yes.
So, when the properties are purchased, a homeowners association may be in effect and already in the neighborhood. Am I right?
Right.
And wouldn't the homeowners policy provide that changes could be made if a certain number of homeowners so voted?
They do.
And this would then eliminate that for these homes.
Right. But again, this bill does not apply to all homeowners associations. This applies to associations that are subject to the Homeowners Association Act. And an association has to affirmatively elect to be a part of that association and to come under the operation of this act. So, I mean, it's not as widespread as you would believe. And then again, the homeowners association groups have agreed that this bill in its form is proper for Georgia. I know there have been concerns about this in other areas of the nation, such as California, and there was a recent, I guess, New York Times article on it. But I mean, those circumstances are different, and it's necessary for Georgia.
Do you further yield?
Yes.
So you said this is only for homeowners associations that have joined the
Georgia Homeowners Association Act, and it's, I may not have the exact name, but you have to affirmatively become a part of that and subject yourself to those rules. And there's certain benefits that can come from being a part of that.
What percentage of, are you aware what percentage of homeowners associations have opted in or joined that particular organization?
Well, you know, in my part of the state, most of them don't. There's some that do. It may be more prevalent in the Atlanta area, especially when you get into your high-end subdivisions that may elect to do that. But
thank you.
Chair recognizes the senator from the 26th for a question.
Thank you, Mr. President. Would the gentleman yield?
yes, sir.
If I join a homeowners association and say I'm a professor and end up with a sabbatical and go to Europe, does that mean I can't rent my house out?
Well, if you bought your house and you want to, and at that time the covenants say that you can rent it out, and then they just decide to change it, it would mean that no, you could not, unless this bill passes. Or if, let's say, if you're a member of the military and you're called overseas to duty and you need to rent your house out, well, this law would protect that member of the armed forces who has to go overseas to serve our country, and it would mean that he could continue to rent his house out.
Well, evidently I'm reading this wrong. It says that 2/3 vote, you can keep me from renting my property out.
Well, that's under, yes, that's right. But that's existing law. We're grandfathering in the ability to continue to rent your house out. You're reading existing law.
Okay. All right.
You have no more questions.
I yield the well.
Does any other senator wish to speak for or against Senate Bill 442? Chair sees none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 33, the nays are 20. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Mr. Secretary, can you please read the caption of Senate Bill 462?
Senate Bill number 462 by Senator Kennedy of the 18th and others. A bill to be titled an act to amend Title VII of the OCGA relating to banking and finance so as to transfer duties, powers, responsibilities, and other authority relative to industrial loans from the Industrial Loan Commissioner to the Department of Banking and Finance, to change the name of such loans to installment loans and for other purposes. Mr. President, on March 3rd, 2020, the Senate Committee on Banking and Financial Institutions recommends that this bill do pass by substitute. Respectfully submitted by Senator Ligon of the 3rd Chair. Mr. President, Senate Committee on Banking and Financial Institutions offers the following substitute Senate Bill 462. A bill to be titled an act to amend Title VII of the OCGA relating to banking and finance so as to transfer duties, powers, responsibilities, and other authority relative to industrial loans from the Industrial Loan Commissioner to the Department of Banking and Finance, to change the name of such loans to installment loans and for other purposes. That please order, Mr. President.
Chair recognizes the senator from the 18th to speak to Senate Bill 462.
Good afternoon, colleagues. Thank you, Mr. President. Happy to tell you this is the last bill of the day. Senate Bill 462 transfers the regulation of industrial loans, which are consumer loans below $3,000 or less, from the Office of the Insurance Commissioner to the Department of Banking and Finance. This will align Georgia with most other states, as the industry is not regulated by the Insurance Commissioner in any other state. And also, it results in financial savings for Georgia. The fiscal note that was prepared, I'm sure the senator from the 48th will be happy to know that we do have a fiscal note on this. And the Department of Audits has indicated that the transfer will save the state approximately $190,000 per year. The groundwork for this bill and this transfer was actually laid years ago. 4 years ago, the Office of Planning and Budget, in its FY 2017 zero-based budget analysis, recommended moving the regulation for industrial loans to the banking department. In 2017, 2 years later, the Department of Audits followed up by recommending that it would be more efficient and a more efficient use of government resources for this program to be transferred to the banking department. OPB and audits say that this will be good from a government perspective and that it should be moved. So to obtain these efficiencies that OPB recommended, the bill makes a few changes. First of all, it does not change the general operation of this industry, such as what the permissible interest rate is, charges, loan caps, and details such as that. Instead, it changes simply the regulatory processes such that the bill overlays the department, the residential mortgage lenders, and money service businesses, and has them apply to the industrial lending business that's done here in Georgia. So in order to obtain these efficiencies, we are proposing to move the operations of this over to the banking department. I'm unaware of any opposition to the bill. The Georgia Installment Lenders Association and the Georgia Financial Services Association, which y'all recognize as the two largest associations that represent the consumer loan industry, support the bill. They support the transfer. Georgia Watch, which is a consumer advocacy group in the financial services arena, also supports the transfer to the department. And importantly, the insurance commissioner does not oppose this. And finally, the banking department supports the transfer. So with that, Mr. President, if I don't have any questions, I'll be happy to yield the well.
Senator, you have no questions.
Thank you.
Does any other senator wish to speak for or against Senate Bill 462? The chair sees none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none and the main question is ordered. The question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. The Secretary will unlock the machine. On the passage of the bill, the yeas are 54, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. For what purpose does the senator from the 52nd rise?
Mr. President, I would move that the Senate agree to the House amendment to the Senate substitute on House Resolution 164.
Mr. Secretary, can you please read the caption of H.R. 164?
House Resolution Number 164 by Representative Powell of the 171st and others. A resolution proposing an amendment to the Constitution so as to authorize the General Assembly to provide by general law for the dedication of revenues derived from fees or taxes to the public purpose for which such fees or taxes were imposed. Provide for procedures, conditions, and limitations. To provide for the redesignation of a current subparagraph of the Constitution and for other purposes. Mr. President, the House offers the following amendment. To amend the Senate substitute to House Resolution 164 by deleting all matter from lines 1 through the end and inserting in lieu thereof the following. Proposing an amendment to the Constitution so as to authorize the General Assembly to provide by general law for the creation or renewal and dedication of revenues derived from fees or taxes to the public purpose for which such fees or taxes were intended. Provide for procedures, conditions, and limitations. Provide for the redesignation of current subparagraphs of the Constitution and for other purposes. That completes order, Mr. President.
Chair recognizes the senator from the 52nd to speak to his motion.
Thank you, Mr. President. This is another of those issues that's been around for quite a while. There were some fees imposed in the 1990s that have not been used for their dedicated purpose, and people would look at it and want, you know, truth in fees legislation, complain of bait and switch. This has been worked on for quite a few years. The late chair of Ways and Means when I started, and then the rules chair, Jay Powell, had been the sponsor of this in the House for several years. It was a passion of his, and Representative Andy Welch took it over for him this year. We've worked out a compromise that gets a little bit closer to the Senate position on this, and what this will do is when fees want to be dedicated, and this will be moving forward, this doesn't go backwards, it will be moving forward, but not retroactive, but 2/3 of the legislatures can dedicate fees, and then in emergency times they can be repealed, and fees can be dedicated in whole or in part on this as well. There are triggers in there because back during the recession, which I missed, I got out of local politics at the end of 2006, came here in 2013, but I know there was a stretch to come up with money, and this says that if there's a 3% downturn in revenue for a fiscal year or 3 months in a row, that it can be repealed, and it can be done for up to 2 years that way, and for any 2-year period and a 10-year period. It also puts a sunset on all of these. We've done sunsets on things in the House, and these have a 10-year sunset on these fees so that we do go back and look at them. We've tried to do a 5-year in the House, but we've had constitutional amendments such as outdoor stewardship, which passed by 83%, fireworks trauma, 81%, that people are going to approve these. And I think this is a more responsible method to look at these going forward. We do limit it to 1% of the total revenue. And of course, this polls very well. 87% agree in a poll that I put on your desk along with some facts that fees paid for a specific purpose should only be used for that. And overwhelmingly support a constitutional amendment. So if this goes forward, it will be on the ballot. The House has already agreed to this 164-4. If it goes forward, it will be on the ballot for this November, and then going forward from there, we will be able to dedicate fees to this purpose. I will add too, when I came here in 2013, there was a young House member that came here at the same year, 2013, and he signed on to this because he believed it was important to him, and he now stands behind me as President of the Senate. So I would urge your favorable consideration of this, and will yield for any questions.
Chair recognizes the Chairman of Appropriations for a question.
Speaker Yield.
Absolutely, you are a great Chair of Appropriations.
Isn't it true that the Senate passed a bill that is very similar to this bill about a year ago, and had a number of precautions in that bill. And isn't it also true that the bill was not retroactive? This bill is not retroactive in that it goes from this day forward. And just basically, isn't it true that it provides a pathway for a dedicated source of revenue for a particular purpose without going through the constitutional processes? Aren't those points true?
That is true. After this point, it won't require going through the constitutional process. It will be 2/3 of the bodies that would do it, and we'll have certainly mechanisms in there when we're in recessionary times.
Isn't it further true that there are some precautions built in that were in our bill that we passed here in the Senate that should revenues take a dip, the governor has a right to, has a responsibility to defer those repayments for fees and put that in the general treasury to meet whatever needs the state has?
Our chair of appropriations knows of which he speaks, and he was very instrumental in doing those into the bill that we worked on in the past, and those have certainly been incorporated into this compromise with the House.
Thank you. I appreciate it and look forward to supporting the bill.
Senator, you have no more questions.
Thank you, and I urge your consideration favorably of this bill.
Chair recognizes the minority leader to speak to the measure, the motion.
Thank you, Mr. President. Members of the Senate, I think this is an excellent piece of legislation. It's a constitutional amendment. It takes 38 votes to succeed today. I think it is important that the legislature establish itself as a powerful force in this government. And us passing dedicated fees as we have in the past, and time again, seeing the governor take those fees and in his budget recommendations direct them somewhere else, or powerful individuals try to redirect money, is not appropriate. So I think this is a great avenue, a well-written bill to help the will of the legislature be fulfilled and our constituents be served. I urge your support and adoption.
Senator has yielded the well. Does any other senator wish to speak for or against the motion? The chair sees none. The senator from the 52nd has moved that the Senate agree to the House amendment to the Senate substitute to H.R. 164. All those in favor of the motion will vote yea. Opposed, nay. The secretary will unlock the machine. On the motion, the yeas are 53, the nays are 0, and the Senate has agreed to the House amendment to the Senate substitute to H.R. 164. Chair recognizes the majority leader for a motion.
Thank you, Mr. President. I move that the Senate stand adjourned until 10 a.m. on Tuesday, 10 March 2020.
Mr. Secretary, can you please read the announcements?
Rules will meet in 4:50 cap. Finance will meet, finance is canceled, insurance and labor is canceled, education and youth is canceled, public safety is canceled, health and human services is canceled, and judiciary will meet in 307 CLOB at 4 p.m. That please order, Mr. President.
Chair recognizes the senator from the 40th for an announcement.
Thank you, Mr. President. Members of the Women's Legislative Caucus, tomorrow morning is the Nikki T. Randall Servant Leadership Award Breakfast. Plan to be there at 7:45, early in the morning, in the Blue Room of the Georgia Freight Depot. Wear black, pearls, and we're celebrating 100 years of women having the vote.
The majority leader has moved that the Senate stand adjourned until Tuesday, March 10th, 2020 at 10 a.m. All those in favor of the motion signify by saying aye. Opposed, no. On the motion, the ayes clearly have it, and we will stand adjourned.